Picture this. You spend hours crafting the perfect prompt, tweaking parameters, and curating results until you create what feels like your masterpiece using AI. But then someone drops a bombshell question that keeps you up at night. Do you actually own what you just made? The answer might shock you. And by the end of this video, you'll know exactly where you stand legally and how to protect yourself in this wild west of artificial intelligence creativity. I'm going to reveal the uncomfortable truth that most creators don't want to face about AI-generated content, the legal loopholes that could cost you thousands, and the surprising strategies that smart artists are using right now to secure their creative future. But first, let me tell you about the creator who thought they owned their AI art until they got hit with a lawsuit that changed everything. Last month, a digital artist posted what they believed was their original artwork created with Midjourney. The piece went viral. Licensing deals started rolling in, and then disaster struck. Another artist claimed the AI had been trained on their copyrighted work. And suddenly, our creator was facing a legal nightmare that could have been avoided with the right knowledge. This story illustrates the complex reality we're living in right now. The intersection of artificial intelligence and intellectual property law is messy, constantly evolving, and frankly, most people are getting it completely wrong. Whether you're creating music with tools like Iva or Suno, generating images with Whisk or Stable Diffusion, or writing with ChatGPT, you need to understand the legal landscape before you invest time, money, and energy into AI-assisted creativity. Let's start with the fundamental question. What does it actually mean to own creative work? Traditionally, copyright law grants ownership to human authors who create original expressions fixed in tangible medium. The key word here is human. For centuries, this system worked perfectly because humans were the only ones capable of creative expression. But artificial intelligence has shattered that assumption, and our legal system is scrambling to catch up. Here's where things get complicated, fast. When you use an AI tool to generate content, multiple parties might have legitimate claims to ownership. There's you, the person crafting prompts and making creative decisions. There's the AI company that built and operates the platform. There's potentially the original creators whose work was used to train the AI model. And depending on how the AI was developed, there might be additional stakeholders with competing interests. The United States Copyright Office has been wrestling with these questions for years. But their most recent 2025 report finally draws a clear line. Copyright only protects the parts of a work where a human determines the expressive elements. In other words, the machine can assist, but it cannot be the author. And here's the part most creators still misunderstand. Writing a clever prompt is not enough. The office explicitly states that prompts alone do not qualify as human authorship, and AI-only output enters the public domain the moment it's created. The Copyright Office used to talk about sufficient human involvement, but the 2025 guidance is much more specific. To claim copyright, your creative contribution must be perceptible in the final work. Selecting from multiple AI outputs isn't enough. Typing a detailed prompt isn't enough. But modifying, arranging, rewriting, painting over, or otherwise shaping the expressive content absolutely can be. AI can generate raw material. The law protects the parts you transform into something that is uniquely yours. Courts are still split, and that inconsistency isn't going away anytime soon. Some judges view detailed prompting as creative authorship, while others insist on substantial human modification. But even with these conflicting rulings, the Copyright Office's stance is now much firmer. AI-only output is public domain, and hybrid works are only protected where the human contribution is clear, original, and visible in the final expression. The situation becomes even more complex when we consider the training data used to create AI models. Most current AI systems were trained on massive datasets scraped from the internet, often without explicit permission from the original creators. This raises serious questions about whether AI-generated content might infringe on existing copyrights, even if you had no knowledge of the training data. Several high-profile lawsuits are currently working their way through the courts. Artists are suing AI companies, claiming their copyrighted works were used without permission to train models. Writers are challenging AI systems trained on their books and articles. Musicians are fighting AI platforms that learn from their compositions. The outcomes of these cases will fundamentally reshape how we think about AI-generated content ownership. Now, let's talk about the practical implications for different types of creative work. If you're generating visual art, the ownership question depends heavily on your level of involvement in the creative process. Simply typing a prompt and accepting the first result probably won't give you a strong copyright claim. However, if you're iterating through dozens of prompts, combining multiple AI outputs, and then digitally painting over the results, you're building a much stronger case for human authorship. Music presents a unique challenge because of how AI music generation typically works. Most AI music platforms create compositions by learning patterns. Where do they learn them from? Existing songs. And then they generate new combinations of those patterns. If you're using these tools, you need to understand that your output might bear resemblance to copyrighted music, even if unintentionally. Some platforms offer royalty-free guarantees, but read the fine print carefully because these protections often come with some significant limitations. Writing with AI assistance occupies a strange middle ground. If you're using AI to generate entire articles or stories with minimal editing, your copyright claims are weak. But if you're using AI as a collaborator, generating ideas, expanding on your concepts, or helping with specific sections while you maintain creative control over the overall work, you're in much stronger territory legally. The terms of service for AI platforms add another layer of complexity that most users completely ignore. Many platforms retain certain rights to content generated on their systems. Some claim ownership of outputs, others grant themselves broad licensing rights, and a few operate on more creator-friendly models. Before you invest serious time in any AI tool, read those terms carefully, because they might override your natural copyright expectations. Here's what smart creators are doing right now to protect themselves. First, they're documenting their creative process extensively. Screenshots of prompts, saved iterations, records of editing, and refinement of their work. This documentation helps establish human authorship if ownership is ever challenged. Second, they're being strategic about which AI tools they use, favoring platforms with creator-friendly terms of service and transparent training practices. Many creators are also developing hybrid workflows that combine AI assistance with substantial human creativity. Instead of relying on AI to generate finished works, they're using these tools for ideation, rough drafts, and technical assistance while maintaining clear human control over the creative direction and final execution. The international picture adds yet another layer of complexity. Different countries are taking dramatically different approaches to AI and copyright. Some nations are more protective of human creators. Others are more permissive towards AI-generated content. And a few are experimenting with entirely new categories of intellectual property rights specifically for AI creations. If you're planning to distribute your AI-assisted work globally, you need to understand how different jurisdictions might treat your ownership claims. What's protected in the United States might be fair game in other countries, and vice versa. Looking ahead, the legal landscape is about to shift again. The Copyright Office is releasing a 3-part series on AI and copyright. Part 1 covered digital replicas and deepfakes. Part 2, released in 2025, clarified that machines cannot hold copyright and that prompts alone don't qualify as authorship. And Part 3, coming soon, will tackle the biggest unresolved issue of all: training data, licensing, and who's liable when AI learns from copyrighted work. Meanwhile, Congress is evaluating new legislation and international bodies are debating whether AI-generated content deserves its own category of rights. Technology is also evolving rapidly. New AI systems are being designed with better provenance tracking, allowing creators to verify that training data was properly licensed. Blockchain-based systems are emerging to help creators establish and prove ownership of AI-assisted works. These tools might solve some current problems while creating entirely new challenges. So, what should you do right now if you're creating with AI? First, assume that pure AI output without human involvement has weak or no copyright protection. Structure your workflow to maximize your human contribution to the creative process. Document everything you do, from initial prompts through final edits. Choose AI platforms carefully, prioritizing those with creator-friendly terms and ethical training practices. Consider registering important works with the Copyright Office. But to be honest about AI's role in creation, misleading the Copyright Office about your authorship can invalidate your registration and create legal problems down the road. Remember that ownership isn't just about copyright. You might have trademark rights in distinctive AI-assisted designs, trade secret protection for your prompting techniques, or contract rights based on your agreements with AI platforms. Think holistically about protecting your creative investments. The future of AI-generated content ownership remains uncertain, but one thing is clear: creators who understand the legal landscape and adapt their practices accordingly will have significant advantages over those who ignore these issues. The Wild West phase of AI creativity won't last forever, and when the dust settles, you want to be on the right side of the law. The relationship between artificial intelligence and creative ownership is still being written, and your choices today will determine your position in tomorrow's creative economy. Stay informed, stay strategic, and most importantly, stay creative while protecting the value you bring to the AI-human collaboration that's reshaping art, music, and content creation forever. Let me know what you think down in the comments, and thanks for joining me here on Inbox Overload.